everyone. 8 p.m. Eastern on Wednesday can only mean one thing. It's another edition of Taxes and Retirement Live. I am your host, Andy Panko. Thank you for joining me. We got a great one tonight that I know you all have been looking forward to. Question and topic that is frequently asked, frequently discussed, often misunderstood. Trust. We have a great guest tonight, an absolute expert in the field. We are in the presence of greatness here. Without further ado, let me introduce you to Bruce Steiner. He's an attorney at Kleinberg, Kaplan, Wolf & Cohen in New York City. Hello, Bruce.
Hi, Andy. Thanks for having me on.
Thanks for being here. So quick background. I met you virtually through the Financial Planning Association in community forums there. And there's a lot of people there who post comments and questions. And there's only a handful that I've said to myself, wow, this person writes thoroughly, consistently, and clearly knows what he or she is talking about. And you were one of them.
Well, thank you.
Anytime there was a trust question, a legal question, you were hands down the most thorough and best answer there. So when I was looking for someone to speak about trusts and the legal ramifications and taxation around them, you were the first one that came to mind, and super excited that you said yes to join us tonight. So thank you.
You're welcome. Happy to.
So, quick background for everyone. Bruce is a seasoned attorney, as I mentioned, at Kleinberg. He focuses, his career has been in trust, in estate administration and taxation, frequent speaker for bar associations, for CPA associations, all over the space of trusts and tax thereon. So author a book as well, or a couple books actually, right, Bruce?
Co-author of a couple of books.
Okay. More than I co-authored. So.
And I think I had the smaller contributions to them.
Cool. I didn't tell you this because I wanted to surprise you ahead of time, but I got this quick bit I do where I say some dad jokes. Usually it's just me talking to an empty crowd, so I don't know how they go over, but hopefully you like it. I'm just randomly picking some. I got a new book here of dad jokes from Dave Fultz in the group. Just got it today. Thank you, Mr. Fultz. All right, Bruce, what do you call a cubic zirconia in Ireland? A shamrock, of course. Right. You laughed. Good. Thank you. This one's kind of easy. What is a boxer's favorite part of a joke? The punchline.
Okay.
And what do you call boxers who can't last in the ring? Briefs. That's a weird one. Okay. All right. Before we get into it, just to protect us all, this video is only general explanations and education. It is not specific tax, legal, or investment advice. Before considering acting on anything you see in this video, first consult with your tax, legal, or investment advisor, which neither Bruce nor I are. We are just here talking about trust tonight. All right. So, Bruce, let's start super elementary. Can you explain for the crowd what a trust is in its purest, simplest sense?
A trust is probably the most wonderful invention of English common law. It basically divides the legal ownership of property from the beneficial ownership. In other words, I can give Andy money as trustee, and it's not his money, it's in a trust, and I say what the terms are. I could say, give my child $1,000 on his birthday every year and until he turns 30, and then give him what's left. Or I could say, use it for my kid however you think is best. And in the meantime, you go invest the money or hire somebody to invest the money however you think is best.
Okay. And that's at the core of it, it is something that's legally distinct, I guess is the right way to put it, from the grantor, from the person who puts the stuff into the trust.
Well, the grantor, or more often the testator, is the one who puts the money in, and the trustees are the people who run it, and the beneficiaries are the people for whose benefit the trustees run it.
Got it. And in the context of retirement planning, or I guess more so estate planning, common question is, do I need a trust? And people are usually referring to a basic revocable living trust. Can you just mention what that is and when it may be appropriate, if
Sure, I
ever?
can create a trust for my own benefit, uh, and then after I'm not around, it functions like a will. It's for the benefit of other other people. I might do it if I'm in a state like California, where it's said to be very, very hard to deal with the probate courts. I might do it in a state like Delaware, where the court charges 1.75% of the estate, not counting the real estate, as a court fee. Uh, there are still a few states left where trustees of a trust under a will have to periodically file accountings with the court. Someone told me Ohio is such a state. Until about 10 years ago, I think Massachusetts was,
Okay.
with the Uniform Trust Code that most states have adopted. Most of the states that used to require that no longer do. So there are fewer and fewer states where you'd have it because you're in that state. You might have it for state income tax purposes. If you're in New York or New Jersey, they treat a trust as a resident trust if the person creating the trust is in that state. And about half the states, notably California, but many others, look to where the trustees are or where the trust is administered. So we had one, the person lived in a state that looked to where the trustees are. And after he died, there was about $10 million of income that came in. And if it had run through his estate, the estate of a resident pays state income tax in that state. But a trust, they didn't tax it because the trustees were not in that state, and the trustees were all in states that taxed the trust based on where the decedent, where the testator or the grantor was. So $10 million of income avoided state income tax entirely. So we sometimes do it to save state income taxes. In New York, the people adversely affected by the probate of a will are interested parties to probating the will. So if I have a will that says I leave my entire estate to my wife and I have kids, my kids would have inherited something had there not been a will, so they become parties to the probate proceeding. Well, if it's my wife and my kids, who cares? But what if I have nobody closer than a cousin and I don't know who all my cousins are? I don't know where my cousins are. I'm a Holocaust survivor and I don't know who my closest relatives are or where they are, or maybe one where they were nieces and nephews and some of those had died and they had grandnieces and grandnephews, and some of those are pretty hard to find.
Mhm.
So occasionally, if you're in a state where the people who would take absent a will become parties and you don't know who they are or where they are, you avoid the struggle of trying to find those people. So there are occasional reasons, even in other states, but for most people and in most states, it's really something that's just overhyped and oversold, either because people are writing books aimed at a California audience, and then somehow people in other states don't realize it's not really for them, or because there are people going around trying to scare people into thinking that all kinds of bad things will otherwise happen. The government will take all the money, or the tax collector will take all the money. Truth be told, it's tax neutral except for this little state income tax quirk. With a couple of very, very minor exceptions, the states and trusts are taxed the same.
Okay.
So it's really the subject we should have put last rather than first. It's sort of like somebody in New Jersey who really, really, really wants to go to New York City and bring a car and avoid that toll in the Lincoln Tunnel. So they go to Newark Airport and they fly to San Francisco and drive to Los Angeles and fly to Kennedy Airport, and you say, why did you do that? And they say, well, I wanted to avoid the toll in the Lincoln Tunnel. They won. They won, right?
Yeah, they avoided the toll, right? Yeah, days and thousands of dollars later, but yeah, they avoided
Right,
that toll.
right.
So, and just basic mechanics of it, still sticking with the living slash revocable trust is, just because I know it's a common question. So if we can just clear up for people what exactly is the structure. So an individual, I can own certain of my things, like my house, like my bank accounts, in the name of a trust, and the trust is its own thing for legal purposes. But while I'm
Yeah, but
alive, it's taxed to me as if it's my own right.
while you're alive, it's disregarded. Although there are lots of irrevocable trusts that are also disregarded while you're alive
Yeah.
too. But it's disregarded while you're alive, and when you die, it functions like a will.
Yeah. And so just to put some terms to it, the person who puts the things in, I'm the grantor of the trust, correct?
Correct.
And the person who oversees it, which typically in a living revocable trust is going to be me while I'm alive, right? But it could be
Well, if it's just you, one of the things that it actually does is it. Some people have had trouble with using powers of attorney, although truth be told, that's gotten a whole lot better, especially as more and more states say if the bank doesn't honor it, they have to pay your legal fees to make them honor
Oh
it.
wow.
And it tends to make them honor it. But anyway, it arguably makes it slightly easier to deal with your stuff if you get disabled. But if you're the trustee, and then somebody else comes along and says, "Well, I'm now the trustee," well, then the bank says, "How do I know you're now the trustee? Go prove it."
Right.
So you really have to have them in as trustee from inception. Otherwise, if the trust says you need two doctors and a veterinarian and a third baseman to certify that you're disabled, and then the time comes you got to go scamper around and go through all those hoops. So it'd be easier if you had somebody in there from day one.
Got it.
But again, this is something it's incredibly overhyped and it's oversold and for most people it's really not necessary, and it's a distraction. We just wasted, we have an hour for this, and we just wasted 10 minutes of our hour on this, and there's just so many substantive things. And some people struggle very, very hard. They're willing to spend a few $1,000s to create a trust to maybe save a few $1,000s of expenses down the road, and then there's issues that could cost or save them hundreds of thousands of dollars or millions of dollars, and they just didn't get to it because they got, people's attention span is limited. That's why your college class is usually about 50 minutes long, because after that, people's attention span is over, and they didn't get to the important stuff.
Yeah. So what? I know you gave a few specific state references where there could be some state tax matters, but outside of the general thought that for most people this basic living revocable trust is unnecessary and kind of waste of effort, and this may sort of parlay us into the next topic, but why else or when else would someone consider, or would they? I'm thinking ahead of like protection and control. But
Florida requires that the personal representative, that's their word for an executor, has to be either a relative or a Florida resident. And if the person you want is your former, you're a snowbird and you move to Florida, and the person you want is your friend from your former state, and they won't qualify, that's a workaround.
To have a trust, you mean?
Yeah, I moved to Florida and I want you as my executor, but they won't let you. They won't let you serve because you're not my relative and you don't live in Florida yet. So if I use one of these trusts, you can be the trustee and do the executor job.
Oh, interesting. I didn't know that. I didn't think about that. Okay.
But again, there are some exceptions, but we ought to focus on the stuff that's more substantively important.
Yeah. So what? With that said, what are the more substantive issues for average random mix of folks like those in this group?
Well, for average folks, the average person sort of has, I don't know, 2.1 children or something like that. So for the average person who's going to either at their death or at the death of the survivor of them and their spouse, is going to probably leave a lot of money most of what they have for their children.
Mm-hmm.
So in our clients' wills, they virtually always provide for their children in their wills in trust, instead of their will saying, if my spouse doesn't survive me, I leave my estate to my children, period, full stop. They say, if my spouse doesn't survive me, I leave my estate to my children in separate trusts for their benefit upon the following terms.
Okay.
And why do I do that? Well, if I leave the money to them outright, it's in their estates for estate tax purposes. And the current level of the estate tax exemption that may not matter for a lot of people. It's subject to their creditors if they run somebody over. If they're doctors and maybe they're concerned about being sued. It's subject to spouses in divorce. In 3/4 of the states, inheritances are not in the pot on divorce, but oftentimes the money gets commingled and the protection gets weakened or lost. But in 1/4 of the states, it's in the pot for divorce. One of my friends going back to junior high school, she from New York, she got married and moved to Boston, or the other way around, and then her parents died and left her some money, and then she got divorced. And in Massachusetts, inheritances are in the pot, so she lost half her inheritance. And also future spouses, you could outlive your spouse and remarry and then die, leaving a new spouse who would then have certain claims. And yes, you could do a prenup, but it would be a whole lot easier if you didn't have to.
Right. And this trust you're speaking of, this, correct me if I'm wrong on the titling or label, but this is a testamentary trust, meaning it's created upon your death
It's
through
created
your will?
upon my death in my will. Although if I expect to have a taxable estate, I might start giving away money while I'm alive.
Yeah.
Set up trusts for people while I'm alive. But when in 2001, only a little more than 20 years ago, the estate tax exemption was $675,000, and we sort of assumed that everybody who walked in the door was going to have a taxable estate. And today, at roughly 12 million and scheduled to drop to about 6 million in 4 years from now, even at 6 million, while a lot of our clients will have taxable estates at 6 million, many of them won't.
Yeah.
So the ones who will should start giving away money now. In fact, they should give away 12 million or 24 million if they're married now, because in case it drops as scheduled to 6 million, they've gotten away with the 12.
Right.
But we still have a lot of people who are not at that level, and for them, they would wait until they die, because on what they hold, they get a basis step up.
Mm-hmm.
So unless they have some non-tax reason to start giving away money, maybe they want to do something for their kids now. They would normally wait until they die.
And what's the benefit? So the trust that's created upon your death by order of your will, what's spelled out in your will, you can say in that whatever you want, like X amount of dollars is to go to this child every year for the next X amount of years, or
You
whatever.
could.
Why not do that in life, though?
They get extra money in the year when the AFC or the NFC team, whichever you prefer, wins the Super Bowl. And
Yeah.
say what you want.
Whatever you want to do. Yeah. Why? What's the harm, or why wouldn't you, if you know you're ultimately going to have what's left of your your financial remains, at least, whatever, go into this trust upon your death? Why not set it up in life? What's the benefit to waiting to have it done through your will upon your death?
Well, you get a basis step up at death for the assets you've retained, and you might need the money for yourself. But if you expect to have a taxable estate, you'd start giving it away now.
To get it out of your name, yeah.
Yeah, because if you give it away, if my spouse and I give away $24 million today, in my case, the check would bounce. But if I had 50 million and I could give away 24, at 50, I probably wouldn't give away that much. But
Yeah, right.
Maybe one of us would give away 12. The income and growth on that money during my lifetime is out of my estate.
Got it. So it's not going to count against you for the
And
estate
I've
tax
used
purpose.
up the 12, even if the exemption is 6 when I die.
Yes. Yeah, they won't. Okay. And is there any particular, well, I guess stepping back again for the crowd. So there's multiple types of trust, but there's revocable and irrevocable. Revocable means while you're alive, things you put in, you can take back out.
Take back,
You
yeah.
still control and own, right? Um, Irrevocable is once it's in there, it's no longer yours. You can't get it out. Let's assume you can't get it out, right? It's no longer yours. You gave up title to it. It's no longer yours to be taxed as yours. Now I know there's intentionally defective ones and things, but
Yeah, actually, most of them, you remain taxable on it while you're alive, because by you paying the tax on the trust income, you shifted more wealth out of your estate, free of estate and gift tax.
into the trust. Once you're dead, obviously you can't take it back because you're no longer in this world. So those are two titles to keep in mind: revocable and irrevocable. That aside, upon your passing, you have this will that's created. Your stuff goes in there. You structured this will however you wanted to structure it, whether it's which and a football conference wins the Super Bowl that year. Is there any particular name, or what does someone even know to ask for? They show up at an estate planning attorney's door and like, I want to trust because when I die, I don't want my son's greedy wife getting her hands on this money. Like, where do you start? What do you ask for?
The lawyer should, without you asking,
Hmm.
uh, the lawyer should basically ask whether at what age the child should control his or her trust,
Okay.
if ever. I mean, depending upon the child's situation, maybe never is the answer. But
Yeah.
most people pick an age like 30 or 35. The younger clients more likely pick 30, and the older clients more likely pick 35 as the age when they think the child is likely to be of suitable age and discretion.
So there's nothing in particular that the client should know when they go to the attorney's office. Just start spelling out, just saying this is what I want to happen, and the lawyer knows how to
Oh
structure what
God!
to
Oh
give to them.
gosh, no. It's like going to the doctor and saying what medicine the doctor should prescribe, or going to the dentist and getting a cavity filled and telling the dentist whether to use the number 2 drill or the number 3 drill.
Right. They're the expert for a reason.
The lawyer should know that you provide for children in trusts that are fully discretionary, and then the issue is, does the child get to control the trust, and if so, when?
Okay. And how much? I guess one of the wrinkles will be state-wise. You brought up a lot of great points, like Florida, for example. If someone's, let's take a retiree, they live here in the Northeast and have a second house in Arizona and Florida, whatever. What wrinkles does this provide? And do you go to an attorney in your home state in the Northeast or down in Florida, Arizona? How does this cross-border stuff work?
It's less of a problem than people make it out to be. We have a concept called full faith and credit, and if the will is, the will gets probated here, and then you just go down there and you get an exemplified copy. That's a copy that the court puts a whole lot of stamps and seals on it, and you send it in the other place, and in some states like Florida or New York with some paperwork. And in New Jersey, if your vacation home's in New Jersey, you don't even need any extra paperwork. You just you just file it.
Okay. And presumably the attorney you're working with, if he or she isn't, are they all somewhat competent in what the other state issues will be, or will he or she reach out to an attorney there to know what they don't know?
There's as much of a variation as there is in whatever, in the skills of shortstops.
Okay. So it all depends.
It all depends.
Is there a source, a network, or whatever you would call it, an association that you would refer people to? I believe there is some sort of estate planning, or maybe it's elder care. But anyway, a spot to go to if someone doesn't know, a local lawyer, or have recommendations where they can go to get hopefully find someone competent.
We tend to know each other in the same way that in any other field, people know each other.
So if someone just walks in, they don't. Let's assume a client doesn't know anyone. From the client's perspective, I mean, I'm looking for an estate attorney. I don't know anyone. Where do I start? Do I go to the guy with the corner office? Who has a shop on the corner, or do I? Is there some better?
That's a real hard question. I mean, it's like finding anything else. How would you find a doctor in a given specialty? How would you find a plumber? How would you find a car mechanic? It's hard. You can ask people who you think might know, and it's hard. But once you get a few names, you can look online, and if you look at their bio, and if you look at the firm's website, and if I need somebody for a personal injury case, and I look at the firm's website, and it says we do patent litigation, and we do tax, and we do estates, and we do zoning, and then all the way down at the bottom of the list, maybe they say, oh, when we do personal injury, it means they don't really do it,
Right.
I just don't want to turn it away. So you can get a sense from the lawyer's bio as to whether they appear credible and whether they're likely to be a good fit for you, and you can tell from the firm's website whether it's likely to be a fit.
Got it. Yeah.
Or you can ask some people who you think might know.
Yeah.
I mean, you can get it. I mean, speaking at a bar association conference counts for more than speaking at the local senior citizens club, and writing an article for a professional, peer-reviewed journal counts for more than if you wrote something in I don't know, the local weekly newspaper of your neighborhood or something.
Yeah. What if you got a really big billboard ad on the side of the turnpike? Does that give you credentials?
Pretty negative. It would probably be a negative credential, right?
Stay away from that. Yeah. Here's the interesting question. So if you have a trust, do you have to file it in your residency state? If not, and you can file it in other states, is there a reason to do so, and which states are more beneficial?
To file a trust, I can't speak for all 50. If there are any states where one files trusts, it would probably be enough. Be very, very few, no more than a couple of them. I think there is one or two where people file trusts.
I guess maybe not file in the sense of put it on record with the local municipality, but when a trust is created, that there's some nexus to the state in which you live or your house is in, or something. No, does that matter? It's completely state agnostic.
Well, a trust is going to be governed by the law of a given state. In about half the states, trusts can run forever, and about half the states, they run for about 90 to 100 years.
Okay.
Trusts each state has a different way of deciding when the trust is taxable in that state. So a trust could easily be taxable in one state or several states or no state, because some states tax trusts by where the person creating it lives, and some states look to where the trustees are or where the trust is administered, and there's all different variations on it. And so you might have some states, if you have a choice, you want it to be taxable nowhere.
Right.
In some states, I can create a trust for my own benefit and have it be protected against my creditors, and there's about a third of the states have that now. So that allows, it is possible but fairly difficult to create a trust for my own benefit that is a separate taxpayer for income tax purposes and not a grantor trust. And I can only do that in a state where I can create a trust for my own benefit and have it not be subject to my creditors. And in that case, I don't care about my creditors. I just want to not pay state income tax on the trust income and gains. We do that a lot for Californians because their income tax goes up to about 13. New Jersey people because their income tax goes up to 10 point something. We used to do it for New Yorkers because in New York City it goes up to like 12 or 14, but New York can't do that anymore. Oregon tax goes up to around 9 or 10. In Minnesota, there's a few of them.
So does that mean so I live in Middle America? No, bad example. I live in New York. Can I get a trust created that's governed by the laws of some state in Middle America just to
Sure.
Okay.
And some people have suggested that it may be enough if you live in New York and the trustee lives in New Jersey and the trust says it's governed by the law of Kansas. But I'm not that aggressive. I'd want to have some connection to that other state, either usually a trustee there.
Got it. Okay.
Does the trick. I get the Third National Trust Company of Topeka or something.
Right. Okay.
So we actually do a lot of them with trustees in Nevada and South Dakota. You could do Delaware too.
So now it's governed by the laws of those states.
And the trust can last forever in Delaware, South Dakota, Nevada is, I think it's 365 years, which is for most people is long enough. And I can not have to pay state income tax in those states.
Okay.
And then in those states there are trustees that for some 4-figure amount per year will serve as trustee as long as somebody else and not they are responsible for the investments.
Okay.
So I can in the states the statute makes it clear I can bifurcate the duties. But again, that's not for the guy worth, that's not for that's for the people whose net worth is, in the 8 or 9 figures. And if it's in the 8 figures, the first digit isn't usually a 1.
Yeah, right. Okay. So makes sense. Another common question we sort of touched on before we went live here. Does it make sense, and if so, when, to name a trust as the beneficiary of a qualified account like an IRA, Roth IRA, 401k?
So our clients provide, for spouses, unless there's a reason not to, so occasionally in a second marriage where there's not enough other assets to provide for the spouse and for the kids. Usually spouses get it outright so they can roll it over, maybe do Roth conversions. But our clients provide for their children in trust rather than outright for all the reasons we talked about, creditors and spouses and estate tax. And an IRA is an asset like anything else. So our default is you would leave it in trust. But there's a tension with retirement benefits because if the trustees accumulate the money, they pay tax at the top rate. It's 37, scheduled to go back to 39.6. And if you're in a high tax state, you pay that as well. And if the trustees distribute out the money, then what did you accomplish? So there's a tension. One solution to that, of course, is Roth conversions, because if you can convert to a Roth, even in the middle brackets, even in the high brackets sometimes, and then the trustees don't have that dilemma, they can accumulate without worrying about paying more income tax. And then there's still a few wrinkles. You still get the life expectancy stretch rather than the 10-year stretch if it's a trust for a disabled or chronically ill person. And that's a little tricky to do it, but it is doable. It has to be a one beneficiary trust during that person's lifetime, basically. Okay. Or you'd have 2 as long as they're both disabled or chronically ill. The other thing that is one of those things, it doesn't fit very often, but when it does, it's wonderful, is to leave the IRA to a charitable remainder trust for somebody. And that's a trust that the beneficiary gets a percentage of the value each year for life. And the percentage is fixed to be the highest percentage such that the value of the child's interest doesn't go over 90% of the initial value. So if my IRA is $1 million, the value actuarially of the child's interest is $900,000, and the value of the remainder interest that the charity gets is $100,000. It doesn't mean the charity gets $100,000. They get whatever's left. So you can't do that for somebody younger than 27. because the payout rate has to be at least 5%, and at a younger age, you wouldn't, you couldn't do it. So it's got to be somebody who's young, so the trust can run for a long time, but at least 27, and they have to have some other money available for one-off needs, because with this trust, it's fixed. It's a formula as to what you get. You can't get more in the year you need money for a down payment on a house, let's say. And the child has to be somebody who's going to need distributions, so that you don't mind the money being pushed out. Somebody who's not likely to have an estate big enough to pay estate tax, and somebody you think is at low risk of a creditor problem, or a divorce, or needing Medicaid. So if you satisfy all those conditions, it works wonderfully, because you get to replicate the life expectancy stretch that you could get before the Secure Act, how horribly named it was.
Yeah. and I can't think through the math as quick in my head, but from the beneficiary's perspective, by doing it through a charitable remainder trust, would he or she ultimately end up getting more or getting less? Or does it
If
depend?
they're relatively young, maybe even 40-ish, they probably get more. Of course, if they die early, they get less. So if they're supporting a family, you might put some life insurance on that child's life, because if they die early, that trust ends and it doesn't go to their family. It goes to charity.
Charity.
But on a young person, it's not that expensive to buy a life insurance policy to cover them until the point when their family, maybe their kids are grown.
Yeah. So for someone, I don't know, 70-something-year-old person, 80, whatever the age is, doesn't matter, I guess, has an IRA, let's just call it $1 million, $2 million. The person passes, that IRA goes to one or two of that person's kids, adult kids. And the decedent, the person who passed, has no concerns or restrictions about wanting or needing to control the kid's use of that money. They're fine letting the kid have it, take it out within 10 years under Secure Act rules. In that case, any point or benefit to create the trust upon your death to leave the IRA to that trust, or just name it to the kid directly?
I mean, again, it's a keeps it out of their estates, but if they're not going to have taxable estates, you don't care.
Yeah.
And it protects it against their creditors and current and future spouses. But some people you're pretty confident are pretty low risk of creditors, and some people are at pretty low risk of divorce, and some people, if they outlive their spouse, are pretty unlikely to get remarried. And so if the risk is low enough, then yeah, you might just say it's sort of not worth the hassle.
Yeah. And by leaving it to a trust, aren't you now, again, assuming you have the trust specifically to keep some or all the assets in there to kind of dribble it out to the beneficiary, then now the trust is the one who has to take distributions within 5 years, correct? Under Secure Act, and pay tax?
It's usually 10. I mean, assuming you qualify, but you wouldn't draft one that didn't qualify, so you get the 10.
Oh, you pass it out to the beneficiary still within 10.
You don't have to. The trustees can distribute or accumulate as they choose.
But if the trust empties out the IRA, or takes all the distributions, I should say, from the IRA within 10 years, the trust pays tax at the trust tax rate.
Yeah, they either distribute it, in which case the protection is gone,
right,
or they accumulate it, in which case
it's taxed to the trust.
Taxed at the higher rates. Although maybe you can do it at maybe there you might care about state income taxes. So if you can, maybe you do it so that you don't pay state income tax.
Yeah.
Oh, and in a couple of states, interestingly, they tax the trust if it's created in the will, or it's not clear. Pennsylvania and Illinois, we know if it's created outside the will, they won't tax it if there's no connection to Pennsylvania, and we don't know whether they'll tax it if it's created under the will. So in an IRA, maybe
Oh, interesting.
Maybe you go create it in a separate trust instrument to
Okay.
receive the IRA, because for most trusts there isn't that much income in them. Right? You have $1 million, it earns 2%. It's
Right.
$20,000 of income. But
Right.
in an IRA, you have $1 million of IRA benefits. The whole thing is income.
That's all in tax income. Yeah.
Yeah.
So I guess, Jackie, the crux of the question, or the crux of the answer, is if you want and or need the protection and control aspect of the trust, then yes, you kind of have to. The downside is the trust then is the one taking the distributions and realizing the income from the IRA, and therefore the trust is paying tax on it, which is almost all going to be 37%, soon to be 39.6, right? Versus the underlying beneficiary, if he or she is not high earner or whatever, maybe 20 something percent, federal tax at least. I'm not talking about state tax. So that's sort of the trade-off you go through with this, right, Bruce? When it's qualified accounts.
I mean, we tend to have our default have it be in trust on the theory that you can always, pay it out or not set it up. Whereas if you started off with outright, you can't put it back into the trust.
Okay.
But if the numbers are not that big and the people are at low risk, then maybe it's just not worth the effort.
Yeah, got it. Here's an interesting one. I think I know your answer, but I'm curious to see how colorful your answer is. Can you set up a trust yourself without hiring an attorney?
Sure.
Like I can do my own tooth extractions if I want to.
It's not hard to do. Buy a pair of pliers, and I think there's a YouTube on it,
Yeah.
and there probably things you can go to a law library and look at some form books. You create your own trust. It might a nationally prominent trust and estates lawyer, now retired, tried setting up a will for himself on LegalZoom, not to actually sign it, but just to see what it was like. And he said it was actually pretty good. He said it didn't offer him all of the choices he would have liked, but but nevertheless he thought it was pretty good. Of course, he had the advantage that when each time it came to a choice and said you could do A or B or C, he knew which one made the most sense for him, and someone else might not know what choices to take. So like if you didn't have to be a doctor to prescribe medicine, you could get a prescription pad and you could fill out a prescription. You just might not prescribe the same thing for yourself that the doctor might prescribe for you. So you could, and maybe some people are sufficiently poor, low net worth, or have sufficiently simple situations that maybe they can, and other times the largest part of our revenue, I think, comes from the small number of sort of contested matters that we get, which are usually not actually people who did them themselves. They're usually people who went to, lawyers who shouldn't be doing this kind of stuff. At least doctors, like an eye doctor isn't going to fix your foot, and the foot doctor isn't going to fix your eye. But I don't know, some lawyers do stuff that isn't really what they do, and and then we end up we can end up spending, the client can end up spending, and we end up receiving, hundreds of thousands of dollars on the back end. So I don't know. It depends.
That's interesting. I was expecting you to just outright poo-poo the idea of anyone ever using LegalZoom or kind of DIY estate document options.
But then there was another fellow who was a pretty smart guy, but not a lawyer, who did something on LegalZoom for himself, and he showed it to me, and I said, no, this doesn't really fit for you. So we've had all kinds of crazy stuff that we say.
Here's
it's I mean, if you've got, sort of even a couple of $1 million, so the cost of having it done is probably not that much in relation to what you have, but as the amounts get smaller, it gets sort of harder.
Okay. Here's just really the second half of the question is what is of interest, or the actual question. Basically, can you clarify what should or shouldn't be in a trust? We already talked about the qualified account things.
It sounds like he's talking about one of those revocable trusts. So if he's in a state where he has a situation where it makes sense to have it, then yeah, they should put everything into it. Well, you can't put retirement benefits into it because an IRA is its own. They're in their own revocable trust already while you're alive, right? It's an agreement with the financial institution. It's your own revocable trust. You could take the money out whenever you want. It's already in one. So if you're in, you'll use California as the example because it's the biggie. Or if you have a case or you're in a state where it makes sense, you should, put your stuff into it. And if you take the other extreme, New Jersey. In New Jersey, at least before the pandemic, the executor could walk into the courthouse with the will without a lawyer, and the clerks in the court will fill out the forms for you and then say sign here, and you sign here, and then your will is probated, and you never have to talk to the court again. It takes about a half hour. So if you're in New Jersey, you would never, ever, ever see one of these things. If you're in California, you would never see somebody that didn't have one of them.
Okay. How about like cars? I understand financial accounts and any cars or other personal effects, reasons you wouldn't put stuff in a trust if you have it or will have a trust.
I don't know. Again, I mainly practice New York, New Jersey, and Florida, where these things aren't. New York and New Jersey, you don't really see them very much, and Florida, you don't really need them very much. So I don't really get into that. And I try not to get involved in people's transferring of cars because each state has its own procedures, and trying to deal with the motor vehicles is like, never going to be. In many states, it's not going to be easy to do. So if he's in a state where it makes sense, or if he's in one of those cases where it makes sense, then he might as well put his stuff into it, and he paid for it already. And if not, if he's in New Jersey, it wouldn't make any difference.
Okay. Question is, if you have an IRA, for example, your spouse is the primary beneficiary, your trust is the secondary. If you die, can it still go to your spouse for him or her to make it their own IRA? Or
if they survive,
so long as they're the primary. Okay.
First in line gets it. But if they're alive, if they're not alive, but you wouldn't make a revocable trust a beneficiary of an IRA because a revocable trust is an administrative thing. It goes out of business quickly.
Yeah, it goes away
and it gets paid to somebody. So you would make those somebodies the beneficiary of your IRA.
Right.
Whether those somebodies are individuals or whether those somebodies are trusts for people, you would make those individuals or those trusts the beneficiaries of your IRA. Why run it through? Why pay it to a trust that then goes out of business and pays out? And there's one fight, and it could cause a problem with the financial institution. We have one right now. Somebody left an IRA to a trust for the benefit of her daughter, and the trust ends when she's 55, which makes absolutely no sense. What is it that when she's not ready to have it, but when she turns 55, all of a sudden she'll become mature? It made no sense at all. But in any event, in that case, it seemed to happen because when the woman died, the daughter was not, and now she is 55, and she is. But anyway, so then the trustee went to the financial institution and said, "Oh, she's 55 now. Now make it an inherited IRA instead of trust as beneficiary. Make it be daughter as beneficiary." And the financial institution said, "Oh, we can't do that." And they hired me, and I went and I talked to them. And I said, "No, we can't do that." And I said, "You mean that you're okay with letting an $800,000 account go leave your firm and go to some other financial institution that knows how to do it? Can you check with somebody higher up the food chain?" And he did, and he basically said, "Yes, I understand what you're saying, and it's unfortunate that you're going to have to move the account from us to our competitor, that other one. There's as you know, there are three very well known large ones that offer, very, very low cost, diversified mutual fund choices for people. And this account was at one of them, and it's soon to be at one of the others of them that seems to know how to deal with this a little better.
Right.
So that's another problem with running an IRA through an administrative trust.
And follow up, what if the trust is listed as the primary and the spouse is the beneficiary? Then
it'd be unusual for a trust for whom. So it would be for somebody.
Yeah. Right.
Usually the spouse comes first because spouses can roll them over. It'd be kind of unusual, but you could do it.
Right.
If the trust is in the first position, trust don't die. So you die, that trust takes. And then, and if you run it through a trust and it's got a marital credit shelter formula, if you distribute it to satisfy the pecuniary share, you've accelerated the income.
Okay.
So that's something not to. That's something basically not to do. The only time you might do it is if there's some incredibly complicated formula in there that you just can't put into the beneficiary designation because there's just no way a financial institution would accept it.
So I have to put in the trust then. Yeah.
No, and then you have to have the trust pay out in fractional. That asset has to get fractionalized, and then if oh my goodness, the one we were about to do it's at that bad financial institution. They just have to move the account. There's others.
Okay.
Right. I don't want to mention names.
They'll be happy to take the business.
Yeah, the other one will take it.
Yeah. Here's an interesting one. When you hire an attorney, should you expect that person to explain the underlying reasons and relevant law for the trust or what it's doing, or is it rude to ask, or does this depend on the attorney that's sitting there fielding the question?
I mean, you're usually discuss what your objective is, and the lawyer recommends how best to accomplish it.
Yeah.
Underlying. And if you're giving away money now, it would usually be in a trust, and I guess you could do there's Gratz and Cuperts, and there's all kinds of things, and they would. And most money that people give or leave is in a trust, is in trust in one way or another.
Yeah. Okay. Here, I think I know what the answer is going to be, but if you wanted to leave most of the money in the trust and just give a percentage of annual gains, I guess gains that the trust earns on the assets, how does that work? Is it simply you can structure it however you want?
You can structure it however you want. Far, far better, though. Whenever you limit or mandate distributions, it's going to come bite you in some way you never expected. We had one who was a credit shelter trust, and it mandated that the trustees pay for the spouse's health maintenance and support. And then when she had to go into a care home, the trust had to pay what Medicaid would have otherwise paid. And that wiped out the inheritance for the children from the previous marriage, one of whom, had money and didn't care, and the other one was literally an artist and did care. Too bad.
Yeah.
We had another one where it was a marital trust and there were limited distributions, and the trust assets were all high basis assets because the corporate trustee didn't invest so well, and the spouse's own assets had all appreciated substantially because she invested better, and so she wanted to make annual gifts to the next generations, and she wanted the trustee to give her money out of marital trust to use. And the trust was limited as to distributions, and we finessed it. We got the trustee to give her money for things that she was otherwise paying for herself, which would free up money of her own to go give. But we would strongly discourage it. We would encourage you to let the trustees decide from time to time what's best.
Okay.
But if you chose to, you could set it up any which way you want. Say that the kid gets $20,000 in the year the NFC team wins the Super Bowl, and $10,000 in the year the AFC team wins the Super Bowl. Whatever you want.
Right. Flexibility makes a lot of value to a lot of people. I don't know how much you get involved in special needs, so no worries if you don't know the answer. But the special needs trust only for disabled adults who have less than $2,000. I guess there's some significance to $2,000. And what if the disabled adult has more than that and is not on Medicaid?
Well, every beneficiary's trust is a special needs trust in the sense that as long as the beneficiary has no entitlement to anything, the trustee can choose not to distribute or can choose to distribute only in a way that won't adversely affect the government benefits. If you know the person already is getting means tested benefits, you stick in a couple of paragraphs that say, it's my intention that the trust will supplement but not supplant the government benefits, and that the trustee shouldn't do anything to jeopardize the benefits unless, after they've really thought about it, they've concluded it's worth it to do what they want to do. And you say that about 3 times so everybody gets the hint. But even if you don't say it, it's what they do, not not whether you put that line in there.
Yeah.
And so you would do it for everybody. And if you know the person already has the special needs, you throw in those couple of paragraphs just to remind everybody that that's what you intend.
But otherwise, it sounds like by its nature, so long as the trust remains distinct from the individual, it already is in essence special needs, in that
it already is.
Come after it.
But if you know the person has special needs, you say it a couple extra times so everybody looking at it.
Got it.
It's a reminder to the trustees. It's a reminder to the Medicaid people. It's just a reminder to everybody that that's what it is.
Okay.
You even call it the so-and-so, special needs trust.
Right.
Just so everybody gets the picture.
So they know. Is this a special needs trust? The answer is yes. Yeah. Okay. We'll do one last question here. Almost hit 9 o'clock. This is one I haven't thought of before. Can trusts distribute in kind, or do they have to liquidate and send cash out?
Trust can distribute in kind. The trust buys a house for a beneficiary to live in, and 5 years later, the trustee says, I don't want to be responsible for this kid's house anymore. Give him the house.
Okay.
So you give them the house.
So you can, and it's just a retitling process, or if it's security, it's just a regular security transfer
You give
process.
them the securities. If it's securities, you can elect to either let it come through at the same basis, or you can elect to treat it as a sale and pay the capital gains tax and get a new basis.
Okay. Interesting. Good to know. All right. We are just about top of the hour here. Bruce, thank you very much. Any parting words of wisdom for the watchers, for the followers? Other than living revocable trusts are overhyped?
Oh, they're incredibly overhyped. I don't know why we wasted so much time on them. Post your questions in the group, and you get the responses of the group.
Yeah, and thank you, Bruce, for the contributions you have made so far.
Thanks.
Very thorough. All right.
Bye-bye.
Thank you very much. Appreciate it. Good night, all.